Hello, everybody. Thank you for joining us on Insurance Law. I'm Scott Seaman, and it's my pleasure to welcome you to our first broadcast in 2022. And so far, I have to say 2022 looks an awful lot like 2021. But on this season premiere episode, we'll be discussing some of the significant cases that were decided in 2021 in the world of insurance coverage. We'll take a look at a couple cases to watch in 2022. Our guest on this episode is a gentleman who follows insurance cases very closely on a daily basis. Shane Dilworth is a reporter who does a tremendous job covering the insurance law beat for Law 360. And if you follow his reporting, he'll be current on important cases and developments throughout the year. Shane, thank you and welcome to Insurance Law.
Hi, Scott. Thanks for having me. It's an honor and a privilege.
Well, before we get into it, why don't you just take a moment or two and tell our listeners and viewers a little bit about yourself and how it was that you got the coveted beat of insurance law for Law 360.
Sure, Scott. I joined Law 360 in June of last year. Before that, I worked for about 17 years at another company within LexisNexis called Mealy Publications, where I covered a lot of different topics. I started off covering pharmaceutical, drug, product liability litigation, moved on to covering discovery, and then moved on to insurance fraud, mortgage lending, construction defects insurance, and that's pretty much how I started covering insurance litigation.
Well, I knew this already, but when I just went and looked at some of your recent articles, you do cover a lot of ground, I have to say. And you brought with you some interesting decisions from 2021 for us to talk about. And I've sort of divided them by topics. And 3 or 4 of the cases you have in mind involve COVID-19 coverage. And I thought I'd just take a moment or so to update everybody on the avalanche of COVID-19 coverage actions. And then Shane will talk about the cases you want to talk about and get some bigger picture insights from you on where you think COVID-19 coverage litigation is heading. But according to the University of Penn Law COVID litigation tracker, as of mid-December 2021, there were approximately 2,100 COVID-19 coverage cases filed across the country. And they break down along these lines. 1,897 involve business interruption, 1,712 involve extra expense, 1,632 involve civil authority. So that's the big massive cases, and then we drop down to a variety of cases under a miscellaneous heading, and maybe 200 or so egress cases, 110 contamination cases, 90 event cancellation cases, 83 suit and labor cases, and about 14 liability cases. So when you look at all those cases, of those 2,100 or so, about 468 were filed as putative class actions, either state, federal, or both. And there were 728 that also included allegations of bad faith. So that's about a third of the cases. And insurers have been doing pretty well at the trial court level. Insurers have prevailed in about 75% of the 160 or so motions to dismiss in state courts, and are doing even better in federal court, prevailing in 95% of the 544 rulings by federal courts. Most of the rulings on the grounds that virus claims do not involve direct physical loss or damage, and I know we'll be talking about that, or because the virus or other exclusion precludes coverage. If you go a little further in cases at the state and federal trial court level, there have been about 52 or so summary judgment rulings in favor of insurers, and policyholders have prevailed in about 11 or 12. And as we'll talk about, insurers have also prevailed in both the first bench trial and the first COVID-19 jury trial. So let's go up to the appellate level, where insurers have won. Well, I had said 13 decisions, but as of yesterday, now it's 14 decisions with another 6th Circuit victory for insurers. But the first 14 U.S. Circuit Court of Appeal decisions on COVID-19 coverage have all been won by insurers. Insurers have prevailed in the 2nd, 5th, 6th, 7th, 8th, 9th, 10th, and 11th circuits. And I think I described that as an inside straight in one of your articles, Shane. And again, mostly based on direct physical loss or damage lacking and some based on various exclusions, virus, microorganism, loss of use ordinance, and law exclusions. So not to leave out Law 360, because you also have a tracker. And I looked a week or so ago, and federal courts have dismissed about 40% of the policyholders' cases. About 17% have been voluntarily dismissed by policyholders, and about 40% have yet to be decided in federal court. And so policyholders hoping to do better in state court, and they have done a little better at the trial court level, but so far the first 3 or 4 decisions, actually 4 decisions, 2 in Ohio, 1 in Indiana, 1 in California, have all been in favor of the insurers. So if you represent insurers, your take so far in the litigation is so far so good. And I think the other thing to be noted is most of the first party coverage cases are behind us. We've seen the rates of filing trickle down considerably, and most first party policies have 1 or 2 year contractual limitation periods. So those cases are likely, most of them anyway, behind us. And with that as by way of background, I want to give you a chance to talk, Shane, since you're our guest. You picked out about 4 cases in COVID-19. So let's start with the oral surgeons versus Cincinnati insurance case and the 8th Circuit decision. Why don't you tell us a little bit about it and its significance?
Well, Scott, before I even get into oral surgeons, there was just another ruling that came down today out of the 2nd Circuit. It was just a summary order that upheld the dismissal of suits brought by, I believe it was 3 delis. And they based their decision on the ruling that came out at the end of December, which was the 112 Holdings case. So you could just chalk that one up to another insurer win there at the federal appeals court level.
So was that one case? So it's 16 wins or 15 wins, or is it 3 cases?
It was one. It's one case.
Okay. Still, we're running the table.
Yeah. If you give me a second, I can pull it up and we can edit that in there if you want to. No. Okay.
So here you go, ladies and gentlemen. This is an example of why it pays to follow Shane, because you get the latest, the greatest information. And for those of you who don't know it, and you wait for your Law 360 note to come in your inbox, you could get the news a little bit earlier by following Shane on, I don't know whether it would be just, what social media are you on?
I'm only on LinkedIn.
LinkedIn. So follow him on LinkedIn and you'll get the news a lot of times the night before, the afternoon before, right?
As soon as it goes live, I usually put it in my feed.
There you go. So talk about oral surgeons.
So I think the biggest part of the oral surgeons ruling was it was the first federal appeals court to reach a decision on whether government orders caused physical loss or damage, because 2021 really was the year of COVID at the federal appeals court level. Scott, as you discussed, it pretty much all the rulings that have come down at that level have been in favor of carriers, but it really started with oral surgeons, and that really did set the bar for how courts should be looking at these cases. In that particular case, the court agreed with the lower court that government orders do not cause or not, the reason for a policyholder's loss, and that those claims aren't covered.
Yeah, exactly. And it did start the momentum off at the appellate court level very nicely for insurers. And the next case you've got is Casey Hops, which is a trial court case. And what's interesting is, policyholder lawyers are very smart. They look for the jurisdictions they think will be most favorable to them. And they found a nice pocket in Missouri where at least one judge there was receptive to their arguments opposing motions to dismiss. So they got beyond the motion to dismiss stage. But I'll let you talk about Hops a little bit, but it sort of underscores the notion that it's a rough road to hoe for policyholders, even if they survive a motion to dismiss.
Yeah, I think the most important finding from Casey Hops is it's the first case to go to a jury, and the jury decided very quickly that I believe it was in under 2 hours that the policyholder's claims failed.
Yes, and then a couple policyholder lawyers have commented that they thought it was because of a particular jury instruction that was given, but it's another example of an insurer win, this time so far the only case to go to verdict. And then I don't know about you, but one of my favorite desserts is mud pie. I love mud pie. And the third case is Mud Pie versus Travelers, which is a Ninth Circuit case.
Yeah, mud pie came out, I believe it was maybe the third time that it reached coming from an appeals court. And yeah, mud pie was actually almost like a trio of rulings that came out at the same day, and they all kind of broke down in different ways the way the policyholders weren't able to sufficiently allege that government orders caused physical loss or damage. Again, it just kind of kept that momentum going in favor of carriers.
And finally, COVID-19 front is the Inns by the Sea case, and that was a California State Court of Appeals case. Why don't you tell us about that one?
Yeah, that was the first state appeals court level to look at government orders causing physical loss or damage. And again, kind of it set the bar that not only are these cases not really persuading federal courts, even state courts are just not really understanding that there's a connection between you can't access your property and that even though you couldn't operate, it's not worthy of coverage.
So really, so far so good in terms of insurers in the U.S. I think, still a significant event from a dollars perspective from the U.S. There, some policies do afford some levels of coverage by particular language or endorsements that they have. There's some cancellation policies, but overall the insurers have done quite well. What do you see as being the next significant case or two that you're waiting on to see how this litigation is going to continue to flow?
I think the next big cases, again, they're at the federal appeals court level, and they're in the First and Second Circuits. The case in the First Circuit is Legal Seafoods. The case in the Second Circuit is Kimchi, and they both are addressing whether virus on premises can cause physical loss or damage. I think that's really where the next generation of COVID cases are going. It seems like the government shutdown order kinds of cases are really kind of dwindling. Obviously, they're really not successful. So I think that's where that's where the beacon is shining right now, is virus on premises cases.
And so that's where you think the policyholders are, their theories have evolved, obviously, as the rulings have come down, and they think their solution will be being able to allege the presence of the virus at the location. There's a lot of problems still, I think, confronting policyholders, including the fact that the presence of the virus itself does not amount to physical loss or damage. But we'll see how those cases play out. Do you think that the policyholders are ready to close things down anytime soon?
I don't think so. I think the science is still being formed for virus on premises cases. I think the ruling, there was an Indiana state court ruling, Indiana Repertory Theater versus Cincinnati Insurance, that came down in the middle of December, where the judge was looking at summary judgment and found that there wasn't enough scientific evidence to prove damage, but she said that there was enough evidence to potentially prove that the virus was there. I think policyholders, it would behoove policyholder attorneys to try to find more science to find that it can cause damage.
Yeah, so we have another situation where maybe litigation and litigation motivations may, and funding by plaintiffs may affect science in an adverse way. We'll have to wait and see how that plays out. Finally, on COVID, let me just get your take on what you see we can expect in terms of COVID claims under other lines of coverage besides first party.
I actually read an interesting article today about cases maybe even trickling down to employees who contracted COVID who will sue their employers, or even family members of employees who contracted COVID who will then go after the employers and try to find them liable. I believe that most states have already kind of foreclosed that avenue of liability, but you never know.
Yeah, and I think we're going to see some activity on professional liability, D&O claims. We're already seeing those claims at least being initiated. So it'll be interesting to see what happens there. So let's get away from COVID and talk about another major area and a topic of a couple of decisions you've identified, which fall under the category of cyber privacy cases. And with all the action on cyber, there have been very few court decisions involving cyber-specific insurance policies, but there have been numerous decisions, the so-called silent cyber decisions, that are decisions under general liability or property or crime policies. And the next case you wanted to talk about, Landry versus Insurance Company of the state of Pennsylvania, a Fifth Circuit decision, is a silent cyber case, correct?
Correct, Scott. Yeah, that case was interesting because it was only a 2-judge panel of the Fifth Circuit in July found that there was a defense owed to Landry's, which is a Houston-based retailer, that there was the duty to defend, and it was a $20 million data breach. And the court found that the definition of the term publication should be interpreted very broadly to find in favor of the policyholder.
Yeah, and really that's the significance of that decision, and as well as the fact that it rejected the idea that a publication by a third party cannot trigger coverage. And other cases have interpreted advertising injury much more narrowly. You know, for example, there's a New York State Court decision involving Zurich and Sony that held no coverage because the publication of private information was done by the hacker and not Sony, the policyholder. And as you mentioned, the breadth of the term publication that court afforded was something that may not jive with people's normal notions of what publication constitutes, but it's not the only case to do that. Couple I just wanted to throw in there real quickly for folks is the G&G oil case decided by the Indiana Supreme Court that leaves open the possibility that ransomware payments might be covered under computer fraud provisions in a commercial crime policy. And I also wanted, and maybe it's because my office is in Illinois, I wanted to talk a little bit about Illinois' Biometric Information Privacy Act and a key decision by the Illinois Supreme Court back in May in the West Bend Mutual case that found that there was a duty to defend a policyholder. The policyholder is a tanning salon, and the claims involved the customer suit that the business disclosed her fingerprints to a third-party vendor, and the court, similar to the Fifth Circuit, went with a very broad definition of publication and found that there was a duty to defend, and also rejected the insurer's arguments with respect to a couple of exclusions. And what's interesting is subsequently a North Carolina federal court in the Massachusetts Bay case, which I know is one that you've covered, came out the other way on the exclusion, but there the exclusion was a more recent version of the exclusion, and the court found that it barred coverage. So there'll be a lot of activity in biometric information cases, not only in Illinois, but a couple of other states this past year have passed similar statutes. So that may be heating up. And it's a good time, I guess, for us to transition to the topic of recoupment, because that's the subject of a couple of the other cases that you selected. The first being Adair from the Ninth Circuit. Why don't you tell us about that?
Sure, Scott. The interesting thing about the Nadir case, it was a case out of the Ninth Circuit where the panel found that Star Insurance Company unit could recoup more than $2 million that it paid to defend that company and its CEO in a suit where they were accused by the then California Attorney General, Xavier Becerra, accusing them of violating the California unfair competition law and fair advertising law. And after the insurer was actually tipped off by someone in the Attorney General's office that there's a California state law that doesn't require them to provide a defense for allegations of violating those laws, that there was no longer that duty to defend. So then the Star unit was sued to get its money back, and it was eventually successful in doing so.
Yeah, and it's interesting. I mean, it's entirely correct that California Insurance Code Section 533.5 provides that there's no duty to defend those sorts of claims. And, more generally, 533 bars coverage for things that could be known loss or intentional acts. So it's an important provision of the code. But what I found very unusual was that the prosecutor went to the lengths of going to the insurance company and telling him it could not defend the policyholder, which one could argue with, although they're correct that may have been overreaching or something not within the province of a prosecutor to do. And then that takes us to, I guess, what is about the 10th case we're discussing today, the Nautilus case. It was also before the Ninth Circuit, but it got booted to the Nevada Supreme Court on a certified question involving recoupment.
Yeah, that case involved a dispute between the insurer and a medical implant company called Access Medical and its manager, Robert Clark. And one of the company's former partners accused Access and Wood of slander and interrupting in business in 2010. The policyholders asked Nautilus to provide a defense, which it did, but it also reserved its right to later challenge its obligations in court. Nautilus then brought its suit in Nevada federal court in 2015, and it sought a determination that it had no duty to defend Access and Wood. In September 2016, U.S. Judge Jennifer Dorsey awarded summary judgment to Nautilus, finding Switzer's actions did not state claims for slander, libel, or other allegations, and that the policyholders made false statements to customers about him. After Judge Dorsey's order, the insurer asked to recoup nearly $500,000 that it incurred in defending Access and Wood. The judge initially denied the request, finding that the insurer did not prove that Nevada law allowed to recover the defense costs, and that Nautilus did not initially seek to recover the costs.
So the interesting thing about the Nautilus case is it was a 4-3 decision by the Nevada High Court, which kind of mirrors what's happening globally across the country, which is that, the insurers have a slight advantage in terms of jurisdictions that allow recoupment of defense cost in the absence of a policy provision when rights are properly reserved. So the court was closely divided on it, but came out in favor of the insurers, and that's sort of what's happening across the country generally on recoupment. And of course, more and more insurers in more recent iterations of policies are putting in provisions that expressly provide for recoupment or reimbursement. So let's travel down to where we'd all like to be this time of year, the Sunshine State of Florida. The next case you picked out deals with an insurer's right to sue defense counsel. It's Arch versus Kubecki Draper. Shane, why don't you tell us about that decision?
The decision from the Florida High Court came down in June, and it found that Arch Insurance Company could pursue legal malpractice claims against a law firm it hired to represent its policyholder, accounting firm Spears, Safer, CPAs, and Consultants, LLC. According to court records, the investment sales company Mutual Benefits retained Spears Safer as an independent auditor. Mutual Benefits was later shut down by the U.S. Securities and Exchange Commission following accusations that it swindled investors out of nearly $1 billion. The SEC sent subpoenas to Spears Safer, and the firm was sued by Mutual Benefits. Arch defended Spears Safer and returned the firm Kubecki Draper, which eventually settled the suit for $3.5 million. The insurer then turned around and brought a legal malpractice suit against Kubecki in Florida State Court, saying the firm dragged its feet when raising the statute of limitations defense on Spear Safer's behalf. The insurer said that if the firm had raised the argument sooner, the settlement amount could have been smaller. Kubicki asked to have the case tossed, arguing that Arch did not have grounds to bring the suit. The firm explained it had no obligation to insure. A Florida state court and an appeals trial court agreed, ruling that there was no privity between the insurer and the law firm. The Florida appeals court also agreed. Arch then asked the Florida Supreme Court to overturn the decisions, arguing that a subrogation clause in its policy to Spear Safer allowed the insurer to stand in the shoes of the policyholder. Sunshine State's High Court disagreed with the lower courts that the firm did not have standing because of a lack of contractual obligation.
Really an interesting case in terms of the subrogation theory that the court went with. Courts across the country are split as to whether or not an insurer can sue defense counsel for malpractice. It seems to me it's a simple issue in tripartite states because there is privity between the carrier and the defense counsel. The other thing at play is, in this case, if the insurer could not sue for malpractice, nobody else would have been able to. But before we leave the Sunshine State, because of the weather that I'm experiencing here in Chicago, I want to linger in Florida a little bit longer and just mention a case decided way back in January 2021 by the Florida Supreme Court, Citizens Property Insurance Corp versus Manor House. That was, I think, a significant case because the Florida Supreme Court ruled that a first-party policyholder is not entitled to extra contractual damages or consequential damages for breach of contract, you can only get those type of damages in a bad faith claim. And the court looked to the Florida legislative history and determined that the Florida legislator enacted section 624.155 to establish a framework for first-party bad faith claims. And in order to recover extra contractual damages, you had to have a bad faith claim. What's interesting there is because the insurance company was a creature of statute, a bad faith claim could not have been filed against it. And before we march on to cases to look forward to in 2022, I also, and there's a lot of other cases we could have touched upon, but I want to touch briefly on the Century Surety case versus Metro Transportation, a Second Circuit decision from October. And the issue there was whether or not, when you had a construction accident, whether the priority of coverage would be determined by looking at the other insurance clauses of the insurance policies or by looking at the underlying indemnity agreements in connection with the construction project. And the Second Circuit said you will look at the underlying indemnity agreements to determine priority of coverage, that the parties contracted among themselves for how coverage and how responsibility would be decided. So you have different approaches throughout the country. Many courts will look at other insurance clauses. Some courts will look as the Second Circuit did here, and New York courts are split on the issue, but we'll look at the underlying indemnity contracts. And then some states, such as Illinois, create fictions such as the targeted tender or selective tender decision. So just a quick reminder for people that sometimes you have to look at the underlying agreements as opposed to the insurance contracts when you're looking to see which insurer or which insurance policy is required to respond. And so with all this action going on in 2021, we're not seeing a slowdown in 2022. And one of the cases that you thought was a case to watch in 2022, Shane, was an opioids decision from the Ohio Court of Appeals, which is now before the Ohio Supreme Court in the Acuity versus Masters case, right?
2022 has really hit the ground running in opioid coverage disputes, Scott, because earlier this week, the Delaware Supreme Court just came down with the ruling that in a case similar to the Acuity versus Masters in the Ohio Supreme Court that found Chubb unit did not, actually it was 3 Chubb units, had no duty to defend Rite Aid in cases brought by 2 Ohio counties that are seeking to recover the increased costs they incurred in responding to the opioid epidemic.
And really the question in these cases are whether these sorts of damages incurred by governmental entities satisfy the requirement of being quote unquote because of bodily injury. And so you see, or in some policies, quote unquote, for bodily injury. And we see decisions going both ways on that. And certainly the Delaware Supreme Court decision is going to be viewed favorably by insurers, and it'll be interesting to see what the Ohio Supreme Court does. There's been a couple of federal court decisions that are similar to what the Ohio Intermediate Appellate Court did with the issue. So opioids, something to watch. And of course, there were a couple of huge opioid settlements recently. So a lot of dollars involved. And I think the other case you wanted people to watch in 2022 was the Bitco versus Monroe case before the Texas Supreme Court.
That's right, Scott. The Bitco versus Monroe case is really the Lone Star State's high court looking at whether in coverage disputes there could be an expansion of what they call the 8 corners rule. Usually you look at the 4 corners of the complaint, you look at the 4 corners of the policy, and that's where you can basically make a determination on if there's a duty to defend. And in some cases where there's potential ambiguity or lack of clarity, there you can, courts can look at it, what they call extrinsic evidence, which is information outside of those two documents. So there's no clear-cut line in Texas as to whether that can happen. So usually with the way it is now, it varies from court to court if that's allowed. So the Texas Supreme Court making a determination there is going to be really important in the Lone Star State.
And the issue, and it's one that is I think subject to some evolvement in Texas now, but generally you can't look at extrinsic evidence to determine the duty to defend, but there's certain, and it varies in state to state, there's certain isolated circumstances where insurers can look at extrinsic evidence to disclaim. And so it'd be interesting to see what the Supreme Court rules and also how broadly or narrowly it rules. Everywhere else in the country, it's called the 4 corners rule. You compare the allegations of the complaint to the language of the policy, but since everything's always bigger in Texas, they call it the 8 corners rule down there. And so, Shane, a lot of interesting cases and some more that we could have covered, but I hope people find that those that we settled on were in fact significant cases. And if they follow you throughout the year, they'll be sure to learn of significant cases throughout the world of insurance as they come down. And one more time, the best way for people to follow you other than in Law 360 itself is on LinkedIn.
That's correct.
Well, thank you. So you now are going to be, your inbox is going to be inundated with requests for you to appear on radio and television shows. You're no longer, just a print media guy. We thank you very much for joining us. We're going to have you back in the near future, certainly before the year's over, to talk about some more cases of interest. Look, we have our own takes. People can look at a couple articles you've done. I know you've written one on some of the significant general liability cases in 2021. You've done an article on significant cyber cases in 2021, and probably some others as well. And we did a recent take in one of your sister publications, Mealy's. In fact, it's going to be running in 7 or 8 of those that talk about some of our takes on different significant cases, not only general liability, but we've taken a look at some other trends and particularly looked at some stuff in D&O and securities law. So very big year 2021, 2022 will not slow down. It does not cease. So Shane, thank you so much for joining us. And ladies and gentlemen, we thank you for joining us. And we look forward to bringing another episode of Insurance Law to you soon. We hope that 2022 is starting out well for you and wish you a very happy, healthy, and productive year. Thanks for listening.